Hi, my name is Cindy Castillo with Castillo Law. Today, I'd like to talk to you about how I approach a DUI case. First of all, it's very important to look at what was the reason for the officer to stop you. In Arizona, the officer has to have reasonable suspicion in order to stop a motor vehicle. Now, what does reasonable suspicion mean? Reasonable suspicion basically means this. The officer has to have more than a hunch that you've done something wrong. The officer needs to either see a traffic violation or he needs to suspect that you might be driving under the influence. Now, some of the things that the officer might look at in terms of whether or not you're driving under the influence are cues that he has been trained on in order to determine whether or not this might be happening. Another reason the officer might be able to stop you is if he believes that you have committed a crime. The second thing that I will look for in determining what is a good DUI case or what might be an issue for a DUI case is what is the reason the officer arrested you. In the state of Arizona, the officer has to have probable cause before he can arrest you. Now, probable cause is a little bit higher of a burden than what reasonable suspicion is. Probable cause basically is it reasonable to assume that a crime has occurred? Now, an officer might gather evidence during his initial investigation in order to determine whether or not a crime has occurred. For example, if the officer witnessed some bad driving, that might be one cue that he would use. Additional information that the officer would use is any statements that you make against your interest. For example, if you make any statements about consuming alcohol or taking prescription medications, these might be cues that the officer would use in the totality of his decision in order to arrest you. An officer might also have you perform some field sobriety tests. The officer sees that you've failed these field sobriety tests or not performed them very well. He would also use those in determining whether or not he has probable cause in order to arrest you. The third step in evaluating your case is looking at whether or not the blood, breath, or urine that was taken on a properly and accurately working instrument. In order to determine whether or not the blood, breath, or urine is accurate and is a good result for the state to use, we would look at all of the instrumentation that was used, whether or not there was any maintenance issues on the instrument, whether or not there was any issues with the chain of custody on the blood or the urine. Also, there are a number of factors that we can look at with respect to the breath and how the blood was analyzed in addition to the urine. The fourth thing that we are looking at when evaluating a DUI case is whether or not there were any issues involving your due process rights. In the state of Arizona, there are minimal due process rights that the officer must adhere to when he investigates you for a DUI. For example, when the officer arrests you, he will take you down to either a station or a DUI van. When he takes you to the DUI van, he typically is going to read you what we call an admin per se or an implied consent. Basically what that is it's a form that the officer is given in order to explain to you your rights regarding providing your blood, breath, or urine to him. Now, if the officer tells you anything that is deemed to be coercive or threatening or offers you any type of leniency, threatens you, if I'm going to take you to jail if you don't provide your urine or your blood, those are issues of due process. Also, the officer must provide you an opportunity to get an independent test. What this means is, once he has taken blood from you, you are given the right in order to go and get your own independent test. So we would look at those issues to determine whether or not the officer has adhered to all of your due process rights. Finally, we will look at any constitutional violations that the officer might have violated while he was investigating you. Again, The officer has to give you a certain amount of information with respect to your constitutional rights. If you ask for an attorney, the officer must stop his proceeding as long as it's still within the 2 hours that he has to get your blood, and he must allow you to speak with an attorney before getting your blood. If the officer does not allow you to get or speak with an attorney, then we have a good shot at being able to suppress the blood results. That means kick out the blood results. Additionally, if you ask to speak with an attorney and you ask to have a private phone call, the officer must allow you an opportunity to speak with an attorney in private. That means behind closed doors. These are just some of your constitutional rights that we would be looking at in evaluating your case. If you have any questions about this, please feel free to call Castillo Law. I do offer free consultations.